All divorces, as it relates to property division, begin with equitable distribution. This means that anything earned during the marriage, does not matter whose name it's in, it could be by the wife, the husband, or spouse, it is all marital. Both parties should leave the divorce with 50% of the marital assets. I often describe it as a pizza because people think, okay, I get half the house, half the car, half the checking account, half the debt. And that would be like you and me going to Pizza Hut, ordering a large pizza with 8 slices and chopping each and every slice in half. You get 8 half slices, I get 8 half slices. That would be weird. We'd be on YouTube, TikTok, Instagram. That's not how it works. Just like you and I would do a Pizza Hut, we cut it in half. So you get 4 slices, I get 4 slices. We put all the assets in a single Excel sheet and make sure that both parties walk away with the same total net value of all the assets. Equitable distribution is an equal division of all marital assets and liabilities. An asset is something that's good, a home, a car, a bank account, an investment account. A liability is credit card debt, the mortgage on a home, a car loan. Florida divides everything equally so that both parties walk away with the exact same net value. Assets like real estate, your family home, or a vehicle are a little bit more complicated. Often both parties are on the mortgage and the note. As part of equitable distribution, one person will either get that asset or it will be sold with the proceeds divided according to whatever is a total net value of 50-50. For example, if one person is on the mortgage, that person can keep the home without having to refi, but they will have to pay out some share of that home. If both parties are on the mortgage and neither person can afford to refinance to buy the other person out, the home may have to be sold. Same is true with vehicles. If a vehicle is upside down, then the vehicle can go to a person, but it will actually be treated as a negative. Ultimately, the courts will never allow a divorced spouse to stay on the mortgage, the deed, or a vehicle title or loan of a person they are no longer married to. We will have to come up with some mechanism to get the asset into one person's name. Separate property or non-marital property is to be completely excluded. If you inherit money from your family, that does not mean your soon-to-be ex-spouse should get half. The same is true of a gift. A gift made during the marriage to one of the spouses is not automatically marital. For example, if your family gets you a new car, that doesn't make it marital just because it got it during the marriage. The same could be true of a painting or even a set of kitchen knives. Non-marital property is non-marital. If you brought it in with you or were gifted it during the marriage or inherited it, it belongs to you and not your spouse. Retirement accounts, 401ks, and pensions are a little bit different because people are always worried about the tax effects. We use CPAs to calculate what the appropriate tax effect should be, which is typically around 20%. The reason for this is you cannot cash that money out today and treat it as if it was a checking account because it's not. It comes with fees, penalties, and interest. What typically will happen in a divorce for, let's say, a 401k would be we would get a court order called a Qualified Domestic Relations Order or a quadro. This splits the account without any tax effects. So in essence, if you have a Fidelity account and some of that is going to your spouse, instead of you cashing it out and paying penalties, we can get a court order that directs Fidelity to create a second account and transfer whatever that portion is. And again, it's not necessarily 50%, but whatever that portion is to the spouse. And if they want to cash it out, if they want to borrow against it, they can pay the penalties, they can pay the fees, not you. Businesses are a very complicated issue in Florida because it is not truly whatever the total business value is, there's also a goodwill value. For example, if you run a lawn care business and you are the only person working, that business ceases to exist without you. Because of that, it could be found that there is no business value, that everything is goodwill value. Further, just because your name is not on the business does not mean you're not entitled to a share of the business. If anything was formed during the marriage, after the wedding date, before the filing date, it is marital regardless of whose name is on the business. Additionally, if a business was formed before the marriage, but it was greatly increased through the marital efforts of either spouse, again, it does not matter whose name it's on, that appreciation or enhancement of value due to the marital efforts, because there is no wife's effort, husband's effort, it's all marital efforts, that enhancement in value could be marital. Typically, we bring in a forensic CPA to determine what is the goodwill value and what is the actual saleable value. While Florida is a no-fault state, there are exceptions to that rule. One exception is in the division of assets, where we can plead for unequal distribution based on dissipation. Dissipation has two elements. Element number one is that it is for a single person's benefit. Number two is it is for that person's benefit outside the scope of the marriage. A perfect example of this would be if your spouse takes their new significant other, not you, while you're married, to Vegas and spends $20,000. They owe that $20,000 back. Or if they used a credit card to incur that $20,000, that is not a marital debt. That is their non-marital debt.